Uh, Good morning. Before Mr. Hibner calls the case, I want to cover a couple of things with the lawyers. We appreciate your agreeing to participate this way. Our remote argument, it enables the court to continue to move forward with the work of the people of the state of Tennessee, which benefits them, all of us, and certainly your clients as well. If we should have any technical issues, we'll take a pause and work them out, but I don't anticipate any now. Mr. Hibner, call the case, please.
Re Chantz B et al.
We'll hear from the appellant.
Good morning, Your Honors. This is Connie Regularly with the Williamson County Bar, and I have asked to reserve 3 minutes.
That'll be fine.
All right, so the matter that is before the court this morning has to do with the wholesale release of juvenile court records to a third party who was not involved in the underlying case, as well as the inappropriate use of a juvenile court adjudication that was appealed to the circuit court, basically looking at the application of 37-1-153 and 37-1-159. To give Your Honors an overview, in short, this was a case where the Department of Children's Services CPS worker Dee Miller secreted a petition to another county without filing it with the DeKalb County Court, but went to Smith County and had a juvenile court order signed in ex parte, and then came back and filed it, knowing that the mother already had an attorney who had already tried to contact her to resolve any issues with an investigation. She set a hearing for the following morning without giving notice to mother or the attorney, and even after several messages were left for her and her supervisor. After several months of wrangling with DCS over discovery, withholding the children, etc., we did have an adjudication in the juvenile court that was timely appealed to the circuit court under 37-1-159. DCS then filed an amended and superseding petition and then dismissed their petition in total, returning the children to the mother. Thereafter, mother filed a 1983 civil rights action claiming some substantive and procedural due process violations against the state actors. The defendants that are before the court this morning, Mr. Cornelius and Mr. Holmes, were employed by the city of Smithville in law enforcement. The claims against them in the civil rights action are Fourth Amendment and Fifth Amendment violations, primarily related to the interrogation tactics on August the 15th through the 17th, only at the very beginning of this case. After that was filed, the defendants retrieved an entire copy of the juvenile court record secretly, without permission of the court, without notice to the mother, in violation of 37-1-153 and 2 protective orders. They filed with the district court some of those records, including the juvenile court adjudication and a perm plan, this juvenile court adjudication, which had been appealed and dismissed. They then, after a complaint was filed by the mother, they then went to circuit court and asked permission to have the file. And then they went to juvenile court and asked permission to have the file. The circuit court and the juvenile court did permit them to have the entire juvenile court file. They filed some of those with the district court, primarily, again, this adjudication order, which we say is moot and of no effect. So the arguments that the plaintiff the mother is making is that under 37-1-153, the state of Harris and Berry v. State, it is pretty clear that those juvenile court records are confidential, and there should have never been a wholesale release of that record. Under 37-1-153, it does provide that with permission of the court, any other person or agency or institution having a legitimate interest in the proceeding or in the work of the court. And we would state that these parties did not have an interest in the proceeding, as the events against them occurred only with the filing of the initial petition. Also under 37-1-153 Part C, it specifically says that notwithstanding the provisions of this section, if a court file or record contains any documents other than petitions and orders, including but not limited to a medical report, psychological evaluation, or any other document, such document or record shall remain confidential. that it was a clear violation of that section. Under 37-1-159, not only is the statute clear that it is a de novo hearing, case law supports that as well. In Green v. Green in 2009 and in N. Ray Landon in 2016, the Court of Appeals has made it perfectly clear that once a juvenile case in a dependent and neglect action is appealed under 37-1-159, it is de novo as if the prior proceeding never occurred. In addition, the Department of Children's Services had filed an omitting and superseding petition. And as I argue in my brief, when that amended and superseding petition was filed, it destroyed the original petition. They never.
Ms. Regularly, Frank Clement here. You're absolutely right that the proceedings in the circuit court would be de novo, meaning the judge has to consider the facts new and fresh, and but I don't see anything that says the documents filed in the juvenile court should be destroyed or put under a concrete bunker. I don't read that from the statute you're relying on.
Oh, it does not say that. It does not say that they should be destroyed, but the adjudicative effect of the juvenile court order is moot and is no longer of any force and effect for any reason.
What about the other files in the juvenile court record?
Well, under 37-1-153, it clearly says that only petitions and orders could be released by the court. So in this case, there were DCS records, there were mental health records, there are foster care review records. None of those should have been released under this statute. If the defendant may have been able, which he did not do, but if the defendants could have come to court and said this one particular document may have relevance, then they might have been able to make an argument. But the trial court erred in the blanket release of that record. So the adjudication, and when we went back to juvenile court, I asked the juvenile court to make a specific finding that the juvenile court's adjudication was superseded by the dismissal in circuit court. And the juvenile court refused to do that, and the circuit court refused to do that. So I'm asking this court, and I ask in my brief for that clarity under 37-1-159, that the juvenile court adjudication is without force and effect when there has been a circuit court de novo appeal, and there is an adjudication out of the circuit court de novo appeal. Now, what the other side is going to argue is, well, they didn't have a trial, they dismissed it, and that's really irrelevant. It's no different that if I go to circuit court and I have a custody hearing and then I appeal it to the Court of Appeals, and the Court of Appeals reverses everything the trial court did. Once the Court of Appeals has done that, the circuit court order is of no force and effect. And that's the same thing here. So the district court allowed those records only because they said the circuit court had allowed those records. So it's a circular argument. They want to say, well, the district court has already considered them, they're already in the record, but the district court clearly allowed it because of the circuit court ruling. So that is, we're asking this court to reverse the trial court. And actually, I went so far as in my appeal is that those records should be collected and destroyed by the parties who have those in their possession. And that if any particular part of that record can be found to be relevant, and the only possible thing that I think might be relevant would perhaps be the testimony of their own witness. So if they wanted the testimony of their witness in that trial, then perhaps they could get it. But we didn't do any of that. The court just gave a blanket release of a whole box full of records. And you all will see when you check that record out, it's literally a box full of records.
Counsel,
so, and then
Counsel, let me interrupt you. How do you suggest we get the records back from the district court?
So if your honors makes a ruling that those records, that the trial court erred because the district court relied solely on the circuit court order. So if this court reverses the circuit court, then that can be filed in the district court as the ruling of this court that it was an error and that those records need to be removed and destroyed. And I'm sure they would do that. Any other questions?
I admire your optimism.
Thank you, Your Honor.
Excuse me for interrupting. With reference to the federal court case, is that currently on appeal, that dismissal?
Yes, it is, sir.
It's pending before the Sixth Circuit?
Yes, it is.
All right, thank you.
Yes. And that issue, so we filed a motion to exclude those particular records from the Rule 12 dismissal, and the district court said that they were public records and the circuit court had granted permission to use them. So we have argued that, and I have again put Tennessee law before the Sixth Circuit, but that is pending on appeal.
Thank you.
Okay. All right. If your honors don't have a specific question, then I will go ahead and pass to the appellees.
Thank you. You have your time for rebuttal. We're here from the appellee.
Good morning, Your Honors, and please the court. My name is Danny Rader. I'm in the Cookville Bar and pleased to be before you today. I've got really three things that I want to talk to you about. The first is the justiciability of this appeal. The second is the appropriateness of the lower court's exercise of their jurisdiction in releasing the records and their proper exercise of discretion in doing so. And then if I have some time, the preclusive effect of the federal court decision, even though it is on appeal to the Sixth Circuit. Beginning with the justiciability of this issue, it's obviously our position that the appeal is moot. And as Judge Sweeney noted, the relief that is sought by the appellant to retrieve these records from the federal district court from its court file, which is, they're not just in someone's possession, they're in the actual filing, and they're on appeal to the Sixth Circuit, and so they've been transmitted to the Sixth Circuit, asking the federal courts to remove those from their file, discard them or destroy them or return them to Ms. Regula. That is not a remedy that I think that this court has the power to impose. And in the absence of any remedy available to the appellant, the case is moot. That's the touchstone for justiciability under the case law, is that there must be some relief available to the appellant. As the court knows, the case law provides that that relief must be available both at the beginning of the case and all the way through the case, including on appeal. And if the case loses its justiciable character in that regard, then the case should be dismissed. This case is moot for the reasons that the records have been filed, they have been considered by the district court, and there really is no remedy available. What the appellant did not mention to the court in her argument, but she did admit in her brief, is that the records that are in dispute were first filed with the federal district court, not by my clients or anyone involved in this appeal. They were filed by Deandra Miller, Angela Brown, Krista Miller, and the attorney Tracy Hertzel, DCS employees and the DCS attorney. They were filed there first by them, completely without any involvement by my clients or the fact that my clients had obtained the record, or that our firm had obtained the records from the juvenile court clerk. Those records, once they were filed with the federal district court, could be relied upon by any party for any reason, colorable legal argument in any event. And the fact that we obtain the records independently does not make those other filings go away. And so that lends to the mootness of this case, because these other parties who are not party to this appeal and who had the records on their own, this is DCS, they had complete copies of the file themselves, that they filed them with the federal district court. There really is no relief for this court to provide to the appellant. Appellant admits that on page 13 of her reply brief, that those records were filed by these other parties in the district court. Now, appellant's argument is that they did not make the same legal argument as to the effect of those filings that my client did, but what legal arguments are made on the documents is a red herring. It has no bearing on the availability of the records. Of course, the key to non-justiciability is whether or not relief is available. This court has held in Groves versus the Department of Safety that we will not decide abstract legal questions or render advisory opinions, and that's what Ms. Regula has asked the court to do. And that dovetails with her request for some sort of declaratory relief. She asked this court to declare that the records in the juvenile court, once the appeal was taken to the circuit court, have no effect. Well, number one, I don't think this court is in, and nor was the lower court, in a position to issue a declaratory judgment in this type of situation. In Groves versus Department of Safety, this court cautioned against trying to join a declaratory judgment action with some appeal of an underlying position, that those two things are incompatible. In any event, TCA section 37-1-159 B does very clearly say that the orders of the juvenile court are not suspended during the appeal. So it's not as if they go away or that there's no effect for them. The statute very clearly says that they continue to have effect. Of course, as Judge Clement noted, the circuit judge will consider everything anew and make their own decision if a trial does eventually happen. And as Ms. Regula noted, no subsequent trial did ever happen. So the only order that's ever been entered is the order from the juvenile court. And then, of course, the dismissal once Ms. Regula's clients mended her ways.
What the order of the juvenile court that you're referring to, is it in effect now?
Ultimately, Ms. Regula's client mended her ways and the case was dismissed. And
the case was dismissed, so that order, it was dismissed on appeal, so that order is of no effect.
It isn't of any effect insofar as how does it affect the outcome of the children, but it may have some effect as to whether or not Ms. Regula's clients have had their rights adjudicated. And that was the issue in the district court as to whether, it's a due process claim. Did these people get due process? Did they have the right to a hearing? And those orders bear on that. And of course, that's not an issue before this court at all as to what is the effect of that with respect to her due process claims or her constitutional claims. Those were before the district court. They've been litigated and adverse to Ms. Regula's clients. A case is moot when it no longer provides a means to provide relief to the prevailing party. That's exactly what the case law says over and over again, and that's exactly what the situation is here. Turning to the circuit court's jurisdiction, Ms. Regula claims that the circuit court did not have jurisdiction to enter its order granting permission. Again, by the time we went to circuit court asking for permission to obtain the file material, the DCS had already filed all of that same file material in the federal district court. We didn't really need to do that, but we wanted to recognize and respect her objection and present it to the circuit court to have the opportunity to get an order from them and resolve that objection. The circuit court did have the authority to enter the order releasing the records because the underlying juvenile case had been appealed to circuit court by that time. Of course, it had then subsequently been dismissed, but pursuant to TCA section 37-1-159C, when there's an appeal taken from the juvenile court, the records have to be transmitted to the circuit court, and therefore they become circuit court records. So the circuit judge certainly had the right to enter an order addressing its own records. And of course, all the courts have the right and authority to supervise all their own files. Ms. Regula then objected to the circuit court judge's order releasing the records. So in a further abundance of caution, we went back to the juvenile court. The juvenile court, again, approved the release of the records. That's entirely in their discretion to do so. What Ms. Regula also did not note in her argument was, and it is contained in the record in this case, is that several other people had already gone to the clerk's office and obtained these records as well. Circuit Judge Amy Hollers, who had been sued as a defendant in the case, had obtained the records. Attorney Sarah Cripps of the DeKalb County Bar, who was serving as guardian ad litem, had already gone to the clerk's office and obtained the records. We were later to the party. And of course, Ms. Regula argues that some of the records we may not be entitled to, or we should have only looked at these certain items. The court should remember that as we get into this case, we weren't part of the underlying, this firm was not part of the underlying court appeal, we didn't know what proceedings there were. We didn't know what documents existed at all. We just asked the clerk, what do you have? And they gave us what they had. Hopefully the clerk will know next time to tell us, no, we need to go to the judge first, but we didn't know whether anything was confidential or not confidential. We just asked the clerk what records were available. But we did go to the court, the juvenile court. The appellant appealed that back to the circuit court. The circuit court again approved the release of the records. So we've got the circuit court twice and the juvenile court once approving the release of these records. And again, moreover, those same records had already been filed by the DCS employees and the DCS attorney who were defendants in that federal case as well, regardless of any of this process. So it was fait accompli before anyone ever looked at anything, before anyone ever asked for anything, because these other parties had already filed it in the district court. To the extent that appellant argues that the circuit court should not, or the juvenile court should not have allowed us to release those records or to have those records, it's clearly within the discretion of the trial court to allow the release of those records when these parties who are participants were being sued. They have a legitimate interest in these proceedings in order to defend themselves in the case. These parties had the right and opportunity to defend themselves, the same as the DCS employees who filed the records independently, the same as Judge Hollers, the same as Sarah Cripps, and the same as everyone else who had been sued in this wholesale collateral attack on the juvenile court process. That is clearly, and I don't see how there can be any colorable dispute that that's a legitimate interest in the proceedings to defend oneself against the process. Of course, all of the records at any time filed by anyone were filed under seal. The confidentiality has been preserved throughout the case. They remain under seal now. The fact that they're not publicly available either through the federal court or here doesn't mean, though, that the parties were not able to share them among themselves and required to do so. So once they were filed, they were, for lack of a better term, fair game for anyone to argue about the effect of that. Turning to the preclusion argument, the federal court has dismissed appellant's case on the merits as to all parties, all defendants. As we noted in our brief, and as Judge Frierson asked, that has been appealed to the circuit court, to the Sixth Circuit Court, and that appeal is pending. The briefing is not completed at this point, and so it may be quite some time before that is resolved. But in the federal system, the district court's decision is final for preclusive purposes. So unlike Tennessee State Court, when there is a lower court decision that is on appeal, for instance, a circuit court decisions on appeal to this court, that ruling is not necessarily preclusive until this court has had its opportunity to render its opinion on the appeal and until that judgment becomes final. The converse is not true in federal court. In federal court, the trial court's decisions do have preclusive effect as to all other federal courts, notwithstanding any appeal. And so this court is compelled under full faith and credit to give the federal decision the same preclusive effect that other federal courts would give it. And so that federal decision rejecting appellant's identical arguments presented in that case does have preclusive effect now and is binding on this court. As appellant noted, she filed a motion to exclude the use of all of these records in the federal district court. She made the same arguments there that she made here, that they don't have any adjudicative effect, that they were void as a result of the de novo appeal, that they should never have been released by the courts. Those arguments were all rejected by the federal court. And as a result of that, having litigated those issues and lost, both collateral estoppel and res judicata apply to preclude these same arguments in this court. Both collateral estoppel and res judicata independently applied. Of course, the distinction being collateral estoppel bars issues that were actually litigated and decided, which this was. Res judicata bars any issues that could have been raised or decided as long as the parties are identical, which this is. And so that both of those doctrines bar appellant's claims now to this court that anything was improper with respect to the use of those records. I understand appellant's argument that she thinks that it's circular because the district court did rely on the circuit court's opinion, an order authorizing the release of the records. But that was just one ground that the district court relied on. In fact, the district court said that, quite frankly, that the appellant did not make any argument or did not even make a reasoned argument as to why the district court could not consider those records. That's what the opinion says. And so the district court did not find the appellant's position compelling, rejected it, and that issue's been fully litigated and decided. So as a result of that, these claims are also precluded. We'd simply say to the court that this is a case that should be dismissed. This appeal should be dismissed because it's moot. There is no remedy available to the appellant. The records have been released. It was proper for them to be released because everyone has an opportunity to defend themselves using these records. That's why these provisions exist in TCA section 37-1-153 to release them. Of course, the judges can obtain them without court permission. The court officials can obtain them without court permission under those preceding sections of Part A. The DCS officials did obtain them. They had them to begin with. They didn't need court permission, and they filed them with the district court, which then made them available to my clients. So we're going around and around about what I'd respectfully submit is nothing. I'll answer any questions the court may have. I'm out of time.
And I hear none. Thank you for your argument. We'll hear from the appellant in rebuttal.
Yes, Your Honors, thank you. Just a couple things I want to address from his argument. One of them is, what relief are we looking for? Now, you asked me some specific questions about the status of the district court, but the relief that we are asking for is to make a finding that the trial court erred and acted in violation of 37-1-153. This is a statute that's in derogation of common law. It is a statute that should be strictly construed. So the court erred, that there's just no dispute about that. So once this court has made a finding that the trial court, because the trial court did not nuance out anything. They didn't say, well, this maybe and maybe not this. They just did a blanket release, which was an error. And as to the part of their defense is seemingly that the DCS defendants filed a petition of which we did not object. This in federal court was a Rule 12 motion. The civil rights litigation has to do with the substantive and procedural due process violations in filing an ex parte order, secreting it to another county, making false statements in the petition. Those are allegations articulated in the civil rights complaint, and they filed that actual petition. That is inside of the Rule 12 permission in federal court, and they did not ask that any of it be considered as for the truth of the matter. So this is a distinct difference between, they had petitions and orders only, which is contemplated under 37-1-153, and they did not ask that they be considered adjudicated facts. The defendants before you today, Mr. Holmes, Mr. Cornelius, and the city of Smithville, it received a blanket acceptance of the file, filed perm plans and other DCS records, as well as an adjudicated order that had been essentially reversed. And just as I said, if this were a custody case and we were in circuit court on a divorce, and the circuit court said one thing, and I came to you and you said something else, and you said, no, the circuit court erred, I could not go back and use that circuit court order against a party in another proceeding. And that's what they wanted to happen. The district court relied upon the circuit court order and said they were public records. Unfortunately, you are the court, you're the state court who has jurisdiction over those records, and that is why we are here today. So the relief we're seeking is that you find that the trial court erred in the wholesale release of those records and did not comply with 37-1-153 and did not take notice of 37-1-159. Thank you.
Thanks. Excuse me. Thanks to counsel for both sides. We appreciate your argument and your briefs. Mr. Hibner, if you'll recess court until 1 o'clock Central Time this afternoon.
This honorable court is now in recess until 1 p.m.